Well, good afternoon. Hello, and welcome to the 5 St Andrews Hill lunchtime webinar on social media and professional regulation. Regulation by the professional regulators of the activities of registrants on social media has been a hot topic for some time and is likely to remain so. It is an area that not only remains vexed by the tensions between the behavioural expectations of the regulators and the private life and freedom of expression rights of individual registrants, but also by the challenges that the regulators themselves face in providing clear and lawful guidance to registrants as to where the line between acceptable and unacceptable use of social media and private messaging apps such as WhatsApp or Facebook Messenger lie. In this webinar, we will be exploring some of the recent case law dealing with these issues, examining a number of the social media policies that regulators have adopted and identifying key themes before looking at some of the issues that can arise during proceedings relating to allegations of misconduct, focusing on social media use, and what we might expect to see developing in the future. I'm Guy Micklewright. I'm a barrister in 5 St Andrews Hill Professional Regulatory Team, having joined Chambers in 2001, previously having spent some 11 years working in-house at Blake Morgan Solicitors. I present and defend cases before all of the statutory healthcare regulators, and I'm regularly instructed to appear in judicial reviews and appeals to the High Court. I'm joined by my colleagues, Amy Wolfson and Joe O'Leary. Amy Wolfson joined Chambers in 2020. She has a mixed practice, but with a focus very much on professional discipline. She acts for regulators and registrants in the full range of fitness to practice matters and associated areas such as inquests. Joe O'Leary also joined Chambers in 2020. He has an expanding practice in professional discipline, and he has acted for both a variety of regulators and registrants at all levels in fitness to practice proceedings. He has recently completed a secondment with the NMC, presenting a variety of cases, but he also acts for the General Dental Council and Social Work England, as well as defending at regulators such as the Health and Care Professions Council. Due to this webinar format, rather than take questions during the course of the webinar, we shall take questions at the end, time permitting. Do, however, feel free to type them into the Q&A box at any time, and they'll be marshalled as the webinar goes on. So with no further ado, I'll hand over, please, to Amy.
Thank you very much, Guy. I'm going to be presenting an analysis of recent case law. It's in three parts. Firstly, typical cases that one comes across in this field. Secondly, a look at the relevant law, but beyond the everyday fitness to practice case law, which we're all familiar with. And thirdly, a look at how the courts have applied the law in those cases where human rights, either Articles 9 or Article 10 of the European Convention on Human Rights, have been engaged. Tess, if you could turn up to my next slide, please. So there are two types of substantive case that you are likely to come across, but I've added a special mention for interim orders because some special considerations apply there. So the first type of case is a case involving discriminatory or offensive behaviour. And the case that I've cited here, Lambert, Simpson and the HCPC, is a very recent case, and it's actually one of Guy's. In short, the registrant, who is a psychologist, was found to have made 3 inappropriate and or offensive comments on Facebook, of which one of them was found to be racially motivated. The registrant denied racial motivation. He said that it was just a badly expressed joke. The panel found misconduct and impairment, and he was given a 4-month suspension order. It's a useful case because in it, Mr. Justice Fordham sets out a test for racially motivated behaviour, and it's in 2 parts. Firstly, was the act in question, so here the posting of the content, did it have a purpose behind it, which at least in significant part was referable to race? And that secondly, it was done in a way showing hostility or a discriminatory attitude to the relevant racial group. The case is interesting because it can be contrasted with the 2021 case of the General Pharmaceutical Council and Ali. That was a registrant who was charged with using anti-Semitic language. The panel in Ali fell into error because they considered what Mr. Ali's subjective intention had been in using the words in question, rather than just the objective meaning of those words. However, where in a case motivation is charged, such as in Lambert-Simpson, the High Court was quite clear that motivation specifically requires the panel to consider a subjective state of mind. I should say there that there are some extracts from these cases and also the statutes that I'm citing that will be in the notes to these slides, which will be circulated. The second type of case, which I've identified, I've described as health misinformation. I should say I've thought carefully about how to label this type of case. It would be wrong to imply that everybody who expresses a view about public health that's contrary to mainstream opinion is spreading misinformation. And in fact, the GMC were criticised in this case, Ardil, for including a charge that the registrant's actions were, quote, contrary to widely accepted medical opinion, although actually it didn't make any difference to the outcome in this case. Mr. Ardil was a surgeon. In 2020, he appeared in a series of YouTube videos in which he made claims such as COVID-19 does not exist, that the pandemic was part of a global conspiracy, that the vaccine could contain microchips, and so on. Panel of the MPTS agreed that Mr. Ardil's actions in appearing in the videos had undermined public health and or were contrary to widely accepted medical opinion and or undermined public confidence in the medical profession. I should add, he did specifically identify himself as a doctor in these videos. He was given a 6-month suspension. Mr. Ardil appealed. He did lose, but the GMC's charging of the case came in for some criticism, and Mr. Justice Swift's analysis of the Article 10 aspects of the case is instructive and something that both I will return to and also Joe. Thirdly, interim orders. The leading case here is White and the GMC. Again, a case that concerns allegations about spreading health misinformation. Being an interim order case, the allegations weren't particularised, but in general terms, it was said that Dr. White had appeared in a video on social media where he'd promoted misleading or inaccurate information about the pandemic, about mask wearing, and about the vaccine. In August 2021, he was given an 18-month interim conditions of practice order, which included the following terms. 1, he must not use social media to put forward or share any views about the COVID-19 pandemic and its associated aspects. 2, he must seek to remove any social media posts he has been responsible for or has shared relating to his views of the COVID-19 pandemic and its associated aspects. The case is important because it considers the application of Section 12 of the Human Rights Act to the granting of relief, which in this context means interim orders. Mr. Justice Dove found that the MPTS had entirely failed to consider Section 12 of the Human Rights Act, and that as a consequence, the interim order could not stand. He observed in passing that the terms of the interim conditions of practice order were so broad that they were unlikely to be proportionate. For example, they would have prevented the registrant from sharing official NHS information about the pandemic. Moving on to my next slide, and we'll take a look at some of the relevant law. Thank you, Tess. So I've highlighted Articles 9 and 10 of the European Convention on Human Rights, both of which are incorporated into domestic law by way of the Human Rights Act. Article 9 protects the right to freedom of thought, conscience, and religion. and Article 10 protects the right to freedom of expression. I would just pause to note that belief in the context of Article 9 is something that has been interpreted quite widely. It's not just a religious belief, it can include a philosophical belief. So, for example, in the Forstater case, which is an employment appeal tribunal case, the claimant's gender critical belief, that is her belief that biological sex is immutable, was accepted as being a belief worthy of respect and protection. Articles 9 and 10 are both qualified rights. And in fact, when one studies the text of those articles, and they are reproduced in the notes which accompany these slides, you will see that Article 10 is more heavily qualified than Article 9. And I would suggest if you have a case involving either of these rights, your first port of call should be a careful look at those qualifications. Moving on, Section 6 of the Human Rights Act quite simply says that it's unlawful for a public authority to act in a way which is incompatible with a convention right. Regulators are public authorities for the purposes of the Human Rights Act, as are their tribunal services and the courts themselves. Section 12 of the Human Rights Act 1998, and this is what was highlighted in the case of White, concerns specifically freedom of expression. Section 12, subsection 2, deals essentially with service, and what it says is, if the person against whom an application for relief is made is neither present nor represented, no such relief is to be granted unless the court is satisfied, A, that the applicant has taken all practicable steps to notify the respondent, or B, that there are compelling reasons why the respondent should not be notified. Note that the requirement here, all practicable steps, goes far beyond what most regulators require as to service, and also what the case law, so Adiogba, says about notifying registrants. In fairness, many regulators go beyond the bare minimum anyway, but in a case where freedom of expression is or may be engaged, regulators should specifically consider Section 12, subsection 2 of the Human Rights Act. Section 12, subsection 3 of the Human Rights Act, and this was something that bit in the case of White, states that in cases involving freedom of expression, no such relief, read interim order, is to be granted so as to restrain publication before trial unless the court is satisfied that the applicant is likely to establish that publication should not be allowed. This is more difficult. It potentially massively increases the work and the time that a regulator is going to be expected to put in before seeking an interim order that touches on a registrant's freedom of expression. It's also going to massively increase the level of analysis that panels will need to conduct when considering such an application. And it's fair to say that the court in White explicitly rejected the GMC's submission that the standard risk assessment necessity considerations that a panel applies when considering an IO are sufficient, to satisfy subsection 3. Finally, I wanted to share Section 149 of the Equality Act. This is what's known as the public sector equality duty, and healthcare regulators, and indeed some other regulators, including the legal profession and the accountancy profession, are listed here as public authorities, are required to have due regard to the need to eliminate discrimination, harassment, victimization, and any other conduct prohibited by or under this Act and associated duties. This is relevant to behaviour which potentially impinges upon the rights of others, and we've seen this cited in respect of sexual harassment cases in the regulatory context. Moving on to my third slide, please. Thank you, Tess. This is a short guide to applying the law whether it's Article 9 or Article 10 in a regulatory context and beyond. So firstly, is the right engaged? Is this a case which concerns the exercise of freedom of expression, or in the context of Article 9, a manifestation of religion or belief? It could well be both. I would just say that there are some beliefs which may be deeply and sincerely held, but are not going to attract the protection of Article 9 or 10. The example given in Fort's data was if you have a genuine and sincere belief in being a Nazi. Secondly, is there an interference with the right? Again, it's likely to be clear on the facts whether there is an interference. It doesn't need to be a direct condition interfering with freedom of expression, like we saw in White. It could be any restriction on a person's freedom to practice that flows as a consequence of their expression of their right, as it was in Ardil. Thirdly, is the interference prescribed by law? This is about legal certainty. Can a registrant understand, with advice if necessary, whether or not their conduct is likely to bring them into conflict with their regulator? In Ardil, counsel for the GMC argued that this condition was satisfied simply because the Medical Act 1983 gave the GMC the power to regulate doctors. This was rejected by the court, which conducted a more detailed analysis, looking also at good medical practice and also the GMC's social media guidance. This is something that Joe is going to come on to in his analysis shortly. It's worth pointing out, however, that the judge did reject the registrant's submission that once you took all of these things into account, so the Medical Act, good medical practice, and the social media guidance, that still wasn't sufficiently clear to meet the prescribed by law condition. Fourthly, is it necessary? And for this, see the qualifications to the relevant right as set out in the ECHR itself. In Ardil, the court considered that interests of public safety, protection of public health, and protection of the rights of others were all material. And finally, is it proportionate? Does the interference go no further than it needs to? This is a familiar concept to panels and all of us at sanction stage, but it also needs to be considered at the misconduct and impairment stages. Although in my view, the existing approach that's taken is likely to be sufficient. I'm going to hand over now to Joe, who will present an analysis of different regulators' guidance and policies on social media. Thank you.
Thanks, Amy. Yes. Tess, could you go to the first slide, please? Thanks. So Adil and GMC was a case that Amy's just mentioned. I've put some parts of the judgment there that can be read. In essence, Mr. Justice Swift didn't accept the submission that general statutory duties of the GMC were enough to meet the foreseeability requirements as required by Article 10 or an interference of Article 10. And Mr. Justice Swift said that it was a combination of the provisions of good medical practice, but also the GMC's social media guidance that ultimately met that prescribed by law condition. So we thought the best way to look at what common issues might come up in the future with regulatory cases in social media, but also to see where regulators or registrants might be going with charges or defences, to look at the various social media guidance that has been set out. There are obviously a number of regulators. We've picked a few examples. Tess, if you could turn to the next slide, please. So the first one to look at in some detail is the Nursing Midwifery Council's document. It's a 9-page standalone document on social media itself. And this is what I would describe as quite a prescriptive document. It's very detailed and it's quite thorough. The first thing to note about the NMC's guidance, and actually most of the guidance that's out there, is that it encourages the use of social media for the building and maintaining professional relationships. But what is interesting about the NMC's guidance and others is that it talks about its use in being able to discuss specific issues and interests, but also clinical experience, which is interesting given the vast majority of the NMC's guidance, but also other aspects of different regulators' guidance have a real emphasis on confidentiality and making sure patient confidentiality is maintained. So it's interesting that regulators are now inviting and encouraging communication between practitioners over clinical experience, but at the same time making it very, very clear confidentiality is at the forefront of everyone's minds. What the NMC have done is refer to their own code, which of course directly references social media, but they've gone a bit further and set out 8 specific examples of when someone's registration or ability to join the register may be at risk, which echoes some of the words stated by Mr. Justice Swift in Adil. Now, these examples, I've included a few of them on the slide there, and one of them, of course, sharing confidential information inappropriately. It's quite broad, it's quite general, but that we can all infer what is meant by that. Then there's also some very specific examples, such as encouraging self-harm or the inciting of hatred or discrimination. Of course, they haven't used the word misconduct in that guidance. It's registration at risk, but it's interesting to see the NMC really prescribing different examples and different types of use of social media that could cause issues. But also with the NMC, and what seems to be, and I'm happily corrected if there's guidance for another regulator that says differently, but what appears to be unique in the NMC's guidance is their specific reminder that if a registrant is aware of another nurse or midwife using social media in any of those 8 ways they set out, that registrant themselves may be under a duty to report. And I think that could really throw up some problems, particularly within WhatsApp groups that many people may be in, where something is said by someone and how far do those duties extend to other members of that group, or more generally, large Facebook groups. And I think that could be an interesting avenue if the NMC do choose to, I've not come across it, but do choose to start charging cases where someone hasn't reported somebody else because they're in the same group. But I think the NMC also set out in their guidance a rather basic home truth regarding confidentiality, where they state that it is unacceptable for nurses to discuss matters of care outside of clinical settings. But as we've said earlier, we have earlier in the document, that encouragement and use of social media in discussing clinical experiences. So it could be argued by some, there is some conflict there within the own document. I'm sure many would disagree with that. But given Adil, and given the comments of Mr. Justice Swift, I think analysis of these documents could really become quite a live issue in FTP hearings going forward. One of the final things to say about the NMC guidance is the concern it raises about acknowledging others on social media, and it acknowledges someone else's post or acknowledging or endorsing someone else's views. They've said it could also become a regulatory concern. So whilst the code doesn't necessarily go into much detail on political views, and the guidance of social media doesn't do so either, what they are very clear about is you have to be very careful what you're like and who you're associating with on social media. Which again, given those large WhatsApp groups people find themselves in, or Facebook groups, or who they follow on Twitter, the guidance, whilst detailed and quite thorough, is also quite broad in its application. Tess, we could turn to the next slide, please. The perhaps other end of the spectrum is the General Pharmaceuticals Council's guidance on social media. It's given a different title. The GPHC's title is about establishing professionalism online, but it's quite clear it does refer to social media. This is very different to the NMC. It's a 1-page document, and it is very general. It asks pharmacy professionals to use good judgment and behave professionally. But what it does again is acknowledge collaboration and how the use of social media is impacting on everybody and changing in our professional lives. As I say, it's nowhere near as prescriptive, and puts forward what I would say is an arguably common sense approach. And a number of the factors included are acting professionally, treating people with respect, maintaining confidentiality, again, professional boundaries, and also a reminder about privacy settings. So here, I think what we see with the GPHC is a very broad document, which in effect simply sets out its code with a slight twist towards social media. If we could turn to the next slide, so I think what everyone would be grateful to see, I'm not going to go through every single regulator's social media code at length and go through every word of it, but here's just some examples of other regulators' social media guidance and the approaches they've taken. The HCPC seem to have taken a form of middle ground. They have one document which firstly sets out a number of top tips about social media. And again, in those top tips, there's a theme of confidentiality coming through, asking registrants to think about who can see their post, but also what may be determine the usual guidance on maintaining professional boundaries. But then what they have, the second section is using social media. And an interesting point it sets out here in terms of maintaining professional boundaries is a requirement to be polite, which is quite interesting to include in the social media guidance. Of course, whilst it's said by the HCPC, you shouldn't be offensive and so on, the use of the phrase not being polite is an interesting one, because of course not being polite may or may not constitute misconduct. And to add that as what may be seen as an obligation to be polite on social media, I think could throw up some issues. I remember I did a case at the HCPC where someone used a relatively mild offensive word in a WhatsApp group. We had a very long debate before the panel about whether that would amount to misconduct or not, and the upshot was it didn't. But the emphasis there on being polite and respectful, I think, could throw up some interesting cases for the HCPC, depending on how they wish to charge. The HCPC also have online a number of case studies and online resources and so on, which registrants, I imagine, would find incredibly useful. However, the GMC, I think, is an example of very prescriptive guidance. Obviously, in a deal that's been set out, it is acceptable to the courts, at least for Article 10 purposes. And whilst it has the usual reminders about privacy and not acting in a discriminatory way, there is some very explicit guidance on what to do in certain situations. It goes really into the details on things such as geotagging and making sure that people can't identify who you're talking about based on where you are, or if a patient is to contact you on their own private social media to your private social media. It even goes as far to give a suggested response. So the GMC is a good example of a very prescriptive guidance, but of course, if something's not included in that guidance, that again, given a deal, might be ripe for debates. The GDC, again, has a number of the usual reminders, if you will, about privacy and not acting in a discriminatory way. But what they've embraced the GDC, it appears, is an acceptance that people will be sharing patient data on social media. A quote from it is, if you are sharing anonymized patient information, you must also take all possible precautions to make sure the patient cannot be identified. And it says, although individual pieces of information may not breach a patient's confidentiality on their own, a number of pieces of patient information published online could be enough to identify them. So it's clearly referring to a form of dogleg identification or jigsaw identification. But it is interesting how the GDC and a lot of regulators now are embracing and accepting social media is now part of not just personal life, professional life, and really managing how information is distributed rather than simply blanket banning it. I've included there, just for some completeness, that the GOC doesn't have specific guidance on social media. It does reference it in its rules, Rule 17.2 of the GOC, the code, sorry, in relation to social media. But whether that will be enough to satisfy a deal, I think remains to be seen. And Social Work England, again, themselves have a short but specific guidance on social media. Tess, if we can move to the next slide, please. So trying to draw together some themes from all the various regulators and their guidance, it does appear there is an active now encouragement in the use of social media in professional lives. And what the guidance seems to be doing now is managing and, well, managing and ensuring that it's done properly in a way that doesn't affect the codes. But the key things that I've really seen coming through these guidance now is confidentiality. It seems to be lit up on almost every regulator's guidance that are very clear on confidentiality. However, as clear as they are in saying it's an important thing to consider, there is again that acceptance of sharing information, but also maintaining boundaries is becoming or is set out very clearly. And I think it's understandable why, given that the social media impact and reach. The last point I raised in the slide there is reporting. It is something raised by the NMC guidance, but how far a registrant will have an obligation to report someone else's use of social media, I think will become very interesting, not least because of what we've seen perhaps in the criminal sphere and police officers being in WhatsApp groups. I'm sure we're all familiar with the news reports, and whether those sergeants or those of higher rank in those WhatsApp groups were under duty to stop and report. I think it'll be interesting to see how that will translate and develop into professional discipline sphere, and particularly healthcare. But it's certainly, I think, an area worth considering and being aware of for the future. So that's my brief overview of some of the different regulators and their social media guidance. I will now hand over to Guy, who will take through his next bit.
Thank you very much, Joe. First slide, please, Tess. Much of what we've looked at, in main part, because it reflects the nature of the case law, has focused so far on the statutory healthcare regulators. However, it must be remembered that all of what has been said thus far applies to regulators in the legal sectors, the education sector, and statutory bodies such as the ARB, or indeed action taken upon those who are registered in the performers lists by bodies such as NHS England. In addition, much will also apply to the accountancy and engineering and similar sectors as that as well, although one has to be careful because a number of these bodies are neither public bodies nor bodies deemed to be exercising a public function, and as a result, convention rights will not be in those circumstances engaged. I'm going to come on and deal with, firstly, a couple of key issues that can arise in social media related cases, and secondly, suggest what I think the immediate future for these sorts of cases might hold. Next slide, please. Time does not permit an analysis of all of the issues that tend to arise on these sorts of cases. There are many, so I propose to concentrate only on two. Firstly, evidential issues regarding the provenance and context of social media posts that form the subject of a regulatory investigation. And secondly, on the question of legitimate comment and appropriate charging in such circumstances. One of the most challenging evidential issues in social media cases can be both the provenance of and the context in which social media posts have been made. More often than not, it seems that complaints which will reach regulators relate to public or semi-public posts on social media platforms which have given rise to concern to the complainant. The complainant tends to screenshot the posts they are concerned about, often on a mobile device, and then sends them off to the regulator, either by email, usually by email or some other form of electronic communication, along with a complaint which has been filled in online or on paper. Sometimes it may be that the complainant and the registrant have previously exchanged posts or comments, but oftentimes they won't have done. The regulator then opens an investigation, possibly, depending on how front-loaded their investigations tend to be. They may get a statement from the complainant exhibiting the screenshots. The regulator will, at some point, if satisfied that there are concerns to be had about the posts, formulate allegations for the purposes of allegations being considered in due course by case examiners, and then they'll be served on the registrant. If not already put on notice, that there's a complaint in the offing, the registrant then, upon having discovered that a complaint has been made and being served with the material which forms the subject matter of the complaint, will often put their privacy settings up, if not already done before, potentially blocks the complainant, and even may delete some of the posts on their social media sites. Now, this causes a number of issues. Firstly, whether or not the offending posts or comments were actually made by the registrant can be challenging to prove should the registrant deny that it was their account. That may be, for example, if the account doesn't bear the same name as the registrant. This is less common on Facebook, but on platforms such as YouTube or Instagram, for the most part, people tend not to use their real names. Same goes often for Twitter. And if there's no photo accompanying those profiles, then that causes additional difficulties. The registrant may claim that the account is a fake one, that they've been cloned in some way, or accept that it is their account, but claim that they've been hacked and locked out of their own account. All of this can be extremely difficult to rebut. Secondly, invariably, complainants have a habit, which is entirely understandable, of only selecting the posts which are of concern to them, and they don't screenshot all of the posts from a particular period or comments that have been made by the registrant. Now, that can mean that it is difficult to present the posts in their proper context. That context can either aggravate or mitigate the conduct, or indeed be essential for the purposes of formulating a case against the registrant, if there is one to answer, and being unable to present that context and not have access to it risks, certainly in certain circumstances, putting a fitness to practice committee in an unfortunate position where it cannot reliably assess the seriousness or otherwise of the posts of concern. Now, of course, there will obviously be circumstances and many circumstances where posts will be of a sufficiently egregious and discriminatory nature in their content, such that there's no context which is likely to give rise to any significant mitigation. But that is certainly not always going to be the case. And thirdly, most social media platforms, again, such as Facebook and Instagram, don't date stamp posts with the year, only the day and the month. And it is only by taking a full copy chronologically of most, if not all, of what has been posted, that one can see when the posts were made. So getting posts in chronological order, depending on the way in which the complaint comes in, the material is provided to the regulator, can be a real challenge. So how do we deal with these problems? Well, one thing that seems to be almost a non-starter for regulators is whether or not they can use their power to compel the production of information to attempt to get information from companies that run the various social media platforms. And none of those companies, on the whole, wish to provide such data and will robustly resist any attempt to get hold of it. Anyone who's been following Elon Musk's approach to how he sees the use of Twitter will be unsurprised by this. Now, this, of course, means that if one is defending and one's client gives instructions denying being in control of the relevant account, and conscious of the fact that where it is easier for a regulator to obtain material which is relevant and disclosable, it is for the regulator to bear the duty of doing so, one can request disclosure of it in the full and certain knowledge that, while the regulator has the power and the obligation to use its statutory powers to seek that evidence, it's almost certainly not going to be able to obtain disclosure of that material. From the regulator's perspective, the best way, perhaps, to deal with these issues, and those defending should also be conscious of this as well, is to seek evidence from the earliest stage in the investigation to tie the registrant to the accounts in question before there's been an opportunity to draw up the shutters. Now, that means not simply relying upon what is said by the complainant, which is all too easy, but proactively accessing publicly available accounts and taking, where possible, a full chronological record of everything posted during the relevant period. And in addition to that, ensuring where possible that statements are taken from witnesses who can give evidence, tying the registrant to using that account during the relevant period. And those may be, for example, people who have exchanged comments on a Facebook page and know the individual independent of their social media account, or through also by private messaging on linked apps, again, such as Facebook Messenger or Instagram Messenger. I see we're already on the relevant slide for the next part, which is legitimate content or legitimate comment, which unfortunately I should say, it shouldn't say context, and charging. We're all probably by now all too familiar with the archetypal racist meme on social media, veiled to a greater or lesser degree as legitimate and reasonable comment. Invariably, these sorts of memes will use apparent concern over something like immigration or safeguarding or crime statistics as a cipher for race. Misogynistic memes sometimes follow a similar line, although sometimes they can be much more overt. However, of particular challenge are cases where one is dealing with, for example, a registrant who shares lots of videos made by controversial figures such as Jordan Peterson, Ben Shapiro, Matt Walsh, or Andrew Tate, videos of that nature. Is this, the question maybe arises, perhaps less so with videos by Andrew Tate rather than the other three. Is this a registrant who is sharing this material because they are cherry picking material to buttress their racist and or misogynistic attitudes? Or are they simply seeing merit in the commentary of figures like these, albeit that they are figures who are, as I say, controversial? Now, the answer to the above question and whether there is a case to be made against the registrant plainly depends on the individual facts, and it will be very fact sensitive. But it will be readily obvious that simply pleading a case as between X and Y date you made discriminatory comments or made discriminatory posts on social media is an exercise that wholly fails to do justice to the issues. And unfortunately, all too often, we are seeing that sort of approach to pleading cases being undertaken by regulators. Referring back to Lambert-Simpson and the HCPC, which Amy's already dealt with in some detail, it seems to me that the High Court have now paved the way for pleading cases, at least in relation to race anyway, in two alternative ways. Either they can be pleaded by reference to the comments or posts themselves as being discriminatory, or secondly, rather than focusing on the posts themselves, the allegations can focus on the motivation, what was in the mind of the registrant when they made the posts and comments that they did. In fact, it seems to me that careful consideration now should be given by regulators as to whether or not a general practice in cases such as these to pleading both of those alternatives should be undertaken, allowing the tribunal the option to find either one or indeed both of those bases proven. As I say, I don't think, as matters stand, that it's simply adequate to plead that between X and Y date, you pleaded one or more comments, you posted one or more comments on social media, and then wrap them up as which were A, inappropriate, B, offensive, or some similar term, is something that is an adequate particularization of these sorts of cases. It seems to me that the impugned comments and posts really should be identified by either date and or their content, because there's no good reason not to. And certainly if this feels like it's going to lead to an unduly burdensome charge, then those dates can simply be particularized in a schedule to avoid it becoming unwieldy. Now, this approach presents some complications when it comes to misogynistic posts that pertain to the protected characteristic of sex, that being a protected characteristic, of course, under the Equality Act 2010. Sexually motivated has a meaning which is now very clearly established in law. We all have, I'm sure, experience of that. And unless the High Court were to extend its meaning in a completely different direction, that does not capture the mischief in question. So there's something of a tension between sexually motivated and racially motivated as a result of the way things have panned out in that case. It remains to be seen, therefore, whether a similar approach in relation to those sorts of posts is something that might be capable of being considered in practice. Offensive is also a word, as I say, that regularly finds its way into social media related charges and reflects the fact that it is a word that commonly features in regulators' social media policies. However, it seems to me that regulators need to exercise some caution when pleading it. It was made clear by the Court of Appeal in Ngole and University of Sheffield that expressing a controversial view using offensive language is a proper matter for a regulator's attention. But the expressing of a controversial view itself is not necessarily, indeed not generally perhaps, a matter for a regulator. Controversial views expressed on social media may well cause offence to some people, but it is the manner of conveying that view that I suggest is for the most part what regulators should be concerned about if they are not to unlawfully interfere with a registrant's Article 10 rights. Pleading a comment or a post as offensive should therefore be approached, I'd suggest, with some care and conscious to carefully identify the gravamen of the concern about the post or comment or tweet. Joe's referred earlier to the requirement, if I can put it as high as that, in the HCPC's guidance to be polite in communication. There are other not dissimilar requirements or suggestions set out in the various social media guidance that some regulators have given. That seems to me that being polite or not being polite falls very far short of amounting to misconduct, and regulators in their policies need to be careful not to set a standard higher than currently the law sets for the behaviour of registrants on social media. Next slide, please. So looking ahead, and there's three things, it seems to me, that we can expect going forward. The first is an increase in the number of cases. It seems clear that the regulator's scrutiny of social media use is only likely to increase, along with the number of complaints. Social media itself is easy for complainants to complain about, and it is, as I say, something which is a live issue as matters stand. Some people just cannot seem to but help themselves in tweeting or posting on Facebook every thought that comes into their head without sitting back for a moment and considering whether or not it's a good idea to do so. And occasionally, unfortunately, that can land them in a little bit of hot water. In respect of the two other areas, the first area, which seems likely to generate more regulatory activity, is clinical misinformation, as was the case in Adil. Already not an insignificant number of cases of this nature have found their way to the regulators, not just the GMC, but also the NMC and the HCPC. And the sanctions in such cases have often been of the more severe kind, suspension and erasure. And that perhaps reflects a tendency of registrants in those sorts of cases, either not to engage or, additionally to that, to show little attitudinal change. The final area it seems to me, where we're likely to see more cases arising relates to gender identity and trans discrimination. I'm sure nobody can but help notice the venom that has been injected into this issue in public discourse. We are currently in an interesting legal position. Under the Equality Act 2010 as it currently stands, someone with a gender recognition certificate or who is currently transitioning is deemed to have a protected characteristic. But it seems that currently, anyway, identifying as, for example, non-binary is insufficient to attract that protection. Now, whether or not that is so, it is a matter of some debate, but certainly that is a view that many adopt. Conversely, it is now clear from force data that declaring yourself to be, for example, a gender critical feminist is a protected philosophical belief under the Act. Therefore, not only is clearly transphobic conduct within the ambit of regulators looking to take action for discriminatory conduct, in my view, but also pejorative posting about those with gender critical beliefs as well. Responding to tweets by a high profile individual such as J.K. Rowling by calling her a TERF or something similar to that should, in principle, we would expect, attract similar action from regulators as if one were to post transphobic tweets. Perhaps you may think, having heard all we've had to say over the last 45 minutes or so, that maybe a good takeaway is don't post anything on social media you wouldn't be happy to have read out in a disciplinary tribunal. Thank you very much. I'm now going to hand over to Amy to make some closing remarks.
Thank you very much, Guy. There's just a couple of questions that have come in, which we'll briefly deal with, and then I'll make some closing remarks. So firstly, there's a question that's been specifically directed at me. Would you regard a chiropractor's belief that spinal adjustments are key to healing and that drugs are not as a protected characteristic for a chiropractor who espoused anti-vaccination views? I think there's three parts to answering this question. Firstly, you would want to conduct an analysis of whether the belief in question could amount to a protected characteristic. And I would refer to the case of Granger, which is an employment appeal tribunal case, for some analysis there. Of course, even if it is a qualified right. So you would need to look at the qualifications to Article 9. I think, however, the trickier thing in this case would be to tie the belief, even if it is genuinely held and capable of being a protected characteristic, to the views expressed about vaccination. I suspect that would be the hardest thing in that example. The next question is in two parts, and I'm going to ask Guy to answer it if that's okay. Firstly, if the registrant disputes being the author of the post and there isn't lay witness evidence available, is it proportionate to use the regulators' statutory powers to seek relevant devices, etc., for the purposes of an expert report? And secondly, should the registrant refuse to provide such material, how is this refusal best relied upon?
Thanks very much, Amy. So firstly, is it proportionate? I always like hearing the use of the word proportionate when it comes to investigations, because sometimes it can become a byword form. Is this going to be unduly difficult and unduly delay the investigation, and can we justify not carrying out this exercise on the ground of proportionality? And one needs to be, I always think, very careful when considering whether disclosure should be carried out and whether it is proportionate to do so, not just to look at the cost and time, but also the importance to the case and the impact on the registrant. So it is inevitably going to be fact dependent. And I'm going to answer this question as though not obtaining that material is likely to result in the case collapsing because you simply can't prove the provenance of the material. I think the starting point is to consider the likelihood of being able to obtain that material and the amount of effort that it's going to require, and the amount of cost it's going to require in light of that. Now, it seems to me that there is rarely a good reason not to, at the very least, draft a letter seeking to exercise whatever power it is that the regulator has, seeking the material. The cost of that is very minimal. Most regulators' legislation gives either some sort of reasonable time limit, such as 2 weeks, before the request becomes potentially enforceable in the court, and certainly 2 weeks on any view is at least a reasonable period to expect a response. So I don't think there's any, generally speaking, good reason not to at least send out a letter. Whether or not it is proportionate, however, to continually engage in litigation with organisations like Meta is not something I'm necessarily persuaded is realistic for the regulators, because the reality is that one would probably end up finding that a significant amount of resource in these sorts of cases, because of course one's talking not just about one case, but about no doubt a number of cases, is being exercised in attempting to get this material. There was a time not so long ago when allegations might be made, where allegations were made of failing to have adequate indemnity. There was a sort of general agreement with a lot of the indemnifiers that provided an order was sought by the regulator for disclosure of indemnity information, that they were quite happy to comply with that without really putting up too much of a fight. But that is not the case when it comes, I would anticipate, to big organisations like Meta. So I think in summary, it's open to the regulators and it's legitimate for the regulators to try, but it's equally legitimate for them to bear in mind that in multiple cases, it's not a good use of registrants' money to be getting into significant litigation, which could use up a lot of resource. In relation to the second part of that, can one ask the registrant to provide the material? Well, it's certainly open to the regulator to do that, and there's obviously an obligation on the registrant to provide that material. And that is certainly a proportionate step that could be taken. The question, of course, is going to be, is it by the time that the request is made, is it the case that that material is still available? Because it may well be, as I say, that the registrant has deleted it. And it's always going to be very difficult to tell whether or not they've done that, should they claim to have done so. If that material is provided, then it can be relied upon. I don't think, however, it could go as far as requiring the registrant to surrender a device. And if it could, I don't think that would be the best use of the registrant's, of the regulator's investigatory resources. I don't think there's benefit to instructing an expert, not least because one doesn't necessarily need an expert to seek to download content. If there's the ability to download content, that's one thing, but I think as a starting point, one should probably consider asking the registrant to provide the material. But as I say, in practice, that may well have disappeared. And it seems to me that the very best thing to be done is right from the off to seek to generate in chronological order the posts which are publicly available before serving the case on the registrant in due course.
Thank you very much for that, Guy. There's a couple of other questions that have come in, but we've gone just over an hour now, so I'm going to need to wrap things up. Our contact details are available, and if anyone wants to continue the conversation offline, you're very welcome to do that. Just a couple of housekeeping points. Everybody who's signed up will be sent a link early next week, both to a recording of this session, but also to the slides. And in the meantime, you can have a look back on our Chambers Knowledge Hub, which has got videos of other events, also articles that we've written, and material from other practice areas in Chambers. So it just remains for me to thank my fellow presenters and to thank everybody who has signed up, joined, and stayed for the duration. Thank you very much, and have a good afternoon.